You think you live in the modern world. And in most respects, you do. You have a smartphone. You have access to the accumulated knowledge of human civilization through a device that fits in your pocket. You travel in metal vehicles, moving at speeds that would have seemed supernatural to a medieval peasant. You eat food that has been preserved through technologies that the 14th century didn't have words for. You live in a world of antibiotics and satellite navigation and streaming services and all the various accumulated achievements of the past several centuries of human ingenuity. And yet, right now, today, in the year you are watching this video, there are laws on the books in multiple countries. Real laws, legally enforceable, some of them never formally repealed, that were written in the medieval period. There are institutions operating today whose structure and whose rules were designed in the 13th or 14th century and have not been fundamentally altered since. There are ceremonies being conducted in public by people in elaborate costumes whose specific procedures were written down when the Black Death was a recent memory and the printing press hadn't been invented yet. This is not an accident, and it is not simply bureaucratic laziness, though bureaucratic laziness is absolutely a factor in some of these cases. It is the product of the specific relationship that certain institutions, the law, the monarchy, the church, the various corporate bodies that the medieval period invented and that proved durable enough to survive into the modern era, have with their own historical continuity. The institution that has been doing something a certain way for 700 years develops a specific investment in continuing to do it that way, partly because the continuity itself is part of the institution's authority, and partly because changing a 700-year-old procedure requires navigating the 700 years of accumulated interpretation and practice that have accreted around it. Some of these rules and institutions and ceremonies are charming. Some of them are genuinely bizarre. Some of them have consequences that affect real people's real lives in ways that the 21st century finds awkward to justify, but has not yet gotten around to eliminating. And some of them are so deeply embedded in the structure of the modern world that changing them would require dismantling things that the modern world has decided it rather likes and would prefer to keep. Let's go through them. The real ones, the ones that survived. Chapter 1. The laws that refuse to die. Medieval statutes that are technically still in force. The law does not automatically expire. This is a fact about legal systems that most people don't think about until they encounter its consequences, at which point they find it either amusing or alarming, depending on how directly the consequence affects them. A law, once passed, remains in force until it is specifically repealed or until a court rules it invalid. It does not fade from existence because it becomes outdated. It does not quietly remove itself from the statute books because nobody has enforced it for 400 years. It sits there, patient, technically valid, waiting for the specific combination of circumstances or the specific individual with the specific motivation to invoke it. The English legal system, the common law tradition that England developed through the medieval period and that spread through British colonialism to become the legal foundation of numerous countries, including the United States, Canada, Australia, India, and dozens of others, is the legal tradition most comprehensively burdened with medieval survivals, partly because of its extraordinary antiquity and partly because of the specific respect for precedent that the common law tradition embeds in its methodology. In common law, old decisions matter. Old statutes matter. The judge who ignores a 700-year-old precedent is a judge who needs a very good reason for doing so. The Statute of Marlborough, passed in 1267 under Henry III, is one of the oldest pieces of English legislation still in force. Parts of it have been repealed over the centuries, but sections of it remain on the books, legally operative, the words of the 13th century still carrying the weight of current law. The statute addressed feudal land law and the specific disputes about distress, the seizure of property as a legal remedy that the 13th century English legal system was concerned with. Its survival into the 21st century is partly the result of the specific provisions it contains that haven't been superseded by later legislation, and partly the result of the English legal tradition's reluctance to formally repeal something that hasn't caused obvious problems recently. The 1267 statute is in good company. The Distress Act of 1267. The Administration of Justice Act of 1285. The Treason Act of 1351, which remains the foundational definition of treason in English law, and whose medieval framework, the listing of specific acts that constitute treason against the king, is still the legal basis on which treason prosecutions proceed in the 21st century United Kingdom, updated and amended over the centuries, but rooted in the specific 14th century document that Edward III's Parliament produced. The Treason Act of 1351 is worth pausing on because its survival tells you something specific about how the legal system manages historical continuity. The act defined treason as compassing or imagining the death of the king, levying war against the king, adhering to the king's enemies, and several other specific offenses against the royal authority that the 14th century considered the most serious possible crimes. The framework is explicitly monarchical. Treason is an offense against the king, and the act's survival into the modern constitutional monarchy requires a certain amount of interpretive creativity to make the medieval framework functional in a world where the king is a constitutional monarch with very different powers from his 1351 counterpart. The creativity has been applied. The courts have managed the medieval framework through the centuries by interpreting its provisions in ways consistent with the modern legal context, and the act has been amended by subsequent legislation that has expanded, modified, and in some areas replaced its provisions, but the foundational document remains. The medieval statute is still there, underneath the subsequent centuries of modification, providing the legal basis that the modern law is built on. The United States has its own version of this phenomenon, though the American legal tradition is considerably younger than the English one. The Constitution of 1787, not medieval, but the oldest functioning written constitution in the world, contains provisions whose specific meaning was determined by the 18th century context, and whose application to the 21st century requires the interpretive work that the American legal culture has been doing continuously since the founding. The Second Amendment, the Third Amendment, the various provisions that were written for a specific historical context and are now applied to a dramatically different one. These are not medieval survivals, but they represent the same phenomenon of historical legal text governing contemporary life. The English law governing salmon fishing in certain Scottish rivers dates to the medieval period and specifies the specific days on which fishing is permitted in terms that reflect the medieval understanding of the salmon's behavior and the medieval church's calendar of feast days and fasting days that organized the week. The fishing regulations that survive from the medieval period are among the more charming survivals because they reflect a very specific, locally detailed knowledge of the natural world that the medieval fishing community had accumulated and encoded in law. The specific weeks when the salmon runs, the specific methods permitted, the specific authorities who enforced the regulations and collected the fees that the medieval administration had decided salmon fishing should generate. The law of treasure trove is another medieval survival with directly contemporary consequences. In England and Wales, the Treasure Act of 1996 replaced the common law of treasure trove. But the Act's provisions reflect the medieval tradition in which precious metals and coins found in the ground belonged to the crown, rather than to the finder or the landowner. The medieval logic was the logic of the feudal system. The king owned the land, ultimately, and therefore owned what was in the land. The modern act maintains the principle that certain archaeological finds of precious metals belong to the crown. Applying a streamlined version of a medieval principle to the world of metal detectors and archaeological surveys, the practical consequence is that a person who finds a medieval hoard of gold coins while metal detecting in an English field is legally required to report it to the coroner, who initiates the treasure process, which ultimately determines whether the find is legally treasure and what compensation the finder and the landowner receive from the crown. The compensation is paid at market value, which is generous by the standards of the medieval original. The medieval finder who concealed their treasure trove and was discovered faced considerably more unpleasant consequences than a reduced compensation payment. The Scottish legal system, which maintained its separate identity from the English system after the Acts of Union of 1707, being based on civil law principles rather than common law, has its own medieval survivals, and some of them are more colorful than the English equivalents. The right of the Scottish public to access private land for recreational purposes, the right to roam that the Land Reform Act of 2003 formalized, is built on a common law tradition of access that has medieval roots, the specific understanding that the public's right to move through the landscape was not eliminated by the private ownership of the land. The Welsh legal tradition contains survivals from the laws of Hywel Dda, the medieval Welsh legal code compiled in the 10th century, the most comprehensive pre-Norman Welsh legal document, that have influenced the subsequent Welsh legal tradition in ways that the lawyers practicing in Welsh courts today occasionally encounter when dealing with the older precedents. The medieval Welsh law's treatment of women's property rights was, in some respects, more favorable than the contemporary English law, a specificity that legal historians find interesting, and that the medieval revival movement finds suitably ironic. Chapter 2: The ceremonies that never stopped. Rituals performed today for reasons nobody fully remembers. You are standing in a field in the English county of Worcestershire. It is a Wednesday in late May. Around you are gathered representatives of the verderers of the Forest of Dean, the official body that manages the ancient Forest of Dean under a legal framework that dates to the Norman period and that has been continuously operative since approximately 1016. They are here to perform the beating of the bounds, the ceremonial perambulation of the forest boundary that the forest law requires to be conducted at regular intervals to maintain the legal definition of the forest's extent. The beating of the bounds is one of the more remarkable surviving medieval ceremonies, partly because it is still performed in multiple locations across England for reasons that are simultaneously ceremonial, legal, and genuinely practical. The ceremony, walking the boundary of a parish or a forest or a piece of common land, stopping at specific boundary markers, performing specific actions at each marker, was the medieval method of maintaining the community's knowledge of its own boundaries in a world without comprehensive mapping. The boundary markers were physical objects, stones, trees, ditches, natural features of the landscape that had been designated as points on the boundary at some point in the past, and that needed to be periodically confirmed in the communal memory. Walking the boundary meant knowing the boundary, and in a world where the boundary of a parish determined who paid which taxes, who was buried in which churchyard, who had access to which common land, maintaining that knowledge had immediate practical significance. The specific actions performed at each boundary marker varied by location and tradition, but the general pattern involved the assembled company, originally the men and boys of the parish, stopping at the marker, performing a specific action to embed the marker's location in memory, and moving on to the next marker. The action was sometimes symbolic, touching the marker, reciting its name, saying a prayer at that point in the boundary. In some traditions, it was more physical. A boy was bumped against the boundary stone, or ducked in the boundary stream, or beaten with a stick at the boundary point. The logic that the physical experience of discomfort at a specific location would ensure the location was remembered is the logic of a world without reliable written records in which embodied memory was the most durable form of information storage. The beating of the bounds is still performed today in numerous English parishes, in the City of London at its ward boundaries, around the Oxford colleges, whose boundaries were established in the medieval period, and whose fellows periodically walk them to maintain the legal continuity of the claimed territory. The Oxford College perambulations are among the more charming survivals. partly because the route of an Oxford college's boundary inevitably passes through parts of the modern city that have changed considerably since the medieval boundary was established, and the fellows performing the perambulation sometimes find themselves beating the bounds of a wall that now runs through the middle of a coffee shop. The ceremony of the keys at the Tower of London is another daily medieval survival. Performed every night without exception for at least 700 years, the ceremony involves the locking of the tower's gates by the chief yeoman warder, the challenging of the party by the sentry, the specific exchanges of word and counter-word that the ceremony prescribes, and the delivery of the keys to the resident governor for the night. The ceremony has a specific protocol, written down, rehearsed, performed, with the precision of a ceremony whose unchanged nature across 7 centuries is itself part of its function. The tower has a Twitter account that announces when the ceremony is completed each evening. The medieval ceremony and the 21st century social media platform coexisting with the specific surrealism that the juxtaposition of the very old and the very new tends to produce. The ceremony was interrupted exactly once in its recorded history. On the night of December 29th to 30th, 1940, when a German bomb landed near the tower during the Blitz, and the explosion disrupted the ceremonial party. The ceremony was completed late that night, and the governor wrote to the king to apologize for the delay. The ceremony, a tradition older than the printing press, wrote an apology letter for being 11 minutes late because of the Second World War. Swan upping is the annual census of the mute swans on the River Thames, conducted each July by the Royal Swan Marker and the Swan Wardens of the Vintners and Dyers livery companies. All mute swans on open waters in England are legally the property of the Crown, a medieval provision dating to the 12th century, when swans were valuable food birds reserved for the aristocracy and the Crown. The Vintners and Dyers companies were granted the right to keep swans by the Crown in the 15th century, and they have maintained that right ever since through the annual counting. The swan uppers travel in traditional wooden skiffs on the river for a week each July, wearing their traditional uniforms, stopping to count and ring the signets and check the health of the swans, and reporting the total to the Crown. The modern function of swan upping is genuinely conservational. The health check and the ringing provide data for the monitoring of the swan population that is now valued as a conservation measure rather than a property inventory. But the legal framework is unchanged. All those swans belong to the Crown, and the medieval provision that made swans royal property in the first place is still operative. The Court of Common Council, the Court of Aldermen, and the Court of the Lord Mayor, the governing bodies of the City of London, the ancient square mile of the original Roman and medieval city, operate under a constitutional framework that is essentially unchanged from the medieval period. The City of London's governance structure was established in the 12th century and has been maintained through the subsequent centuries with such fidelity to the original that the city remains legally a distinct entity from the rest of London, with its own police force, its own elections in which businesses as well as residents vote, its own Lord Mayor who is a different person from the Mayor of London, and its own constitutional position that the Westminster Parliament has consistently treated with the specific deference owed to an institution that is older than the Parliament itself. The election of the Lord Mayor of the City of London involves a ceremony, the silent ceremony, in which the outgoing Lord Mayor presents 2 candidates to the assembled aldermen and the assembled liverymen separately, in a process whose specific ritual forms were established in the medieval period, and whose silence, the ceremony is conducted in a silence broken only by the stamping of feet to indicate approval, is a survival of the medieval understanding that the election of the Lord Mayor was a matter of such gravity that words were insufficient to the occasion. The woolsack in the House of Lords, the large red cushion stuffed with wool on which the Lord Speaker sits, is a medieval survival that is simultaneously symbolic and historically instructive. The woolsack was introduced in the reign of Edward III in the 14th century as a reminder of the importance of the wool trade to England's prosperity. The Lord Chancellor sitting on the wool reminded the assembled lords that the wealth of the kingdom rested on its most important trade commodity. The wool industry has not been England's most important economic sector for several centuries. The woolsack remains. Chapter 3. The institutions that medieval England invented and that are still running. Parliament is a medieval invention. This is easy to forget when Parliament is in the news for its contemporary dramas, the votes, the debates, the procedural maneuvers, and the party politics, and the general theater of the modern democratic process. But the institution, the specific idea that the king should consult with representatives of the realm before taking certain actions, particularly taxation, and that those representatives should meet in a formal assembly with specific powers and specific procedures, is a medieval idea developed in the 13th century, formalized through the subsequent centuries, and still operative today in a form that would be recognizable to Edward I, even if the specific content of the debates would require some explanation. The Model Parliament of 1295. The Parliament summoned by Edward I that is considered the first reasonably representative English Parliament, including knights from the shires and burgesses from the towns alongside the bishops and the great lords, established the framework that the subsequent development of Parliament built on. The idea that the Commons, the non-aristocratic, non-clerical element of the political community, had a formal role in the legislative process was the specific innovation of the late 13th century that has proved across the subsequent 7 centuries to be one of the most durable political innovations in history. The specific procedures of the modern Parliament, the reading of bills 3 times before they are voted on, the division into 2 houses with different roles and powers, the role of the Speaker as the presiding officer, the specific rules of debate that govern the conduct of business, are developments of the medieval parliamentary tradition, some of them unchanged in their essentials from the 14th and 15th centuries. When they were established, the 3 readings of a bill, the procedure by which legislation is formally introduced 3 times in each house before being voted on, dates to the medieval period when the readings were literal. The text of the bill was read aloud to an assembly, most of whose members couldn't read it themselves, and the 3 readings gave the assembled members the opportunity to hear it multiple times and understand its content before committing to a vote. The literacy rate of the modern Parliament is somewhat higher than the literacy rate of the medieval one, but the 3 readings remain, a ceremonial survival of the time when reading aloud was the primary means of making a text available to an assembly. The gentleman usher of the black rod, the official whose role includes summoning the House of Commons to the House of Lords for the state opening of Parliament, performs a ceremony that is a direct survival of the medieval constitutional settlement between the Crown and the Commons. Blackrod arrives at the Commons chamber. The doors of the Commons are shut in his face, the specific theatrical gesture of the Commons' independence from the Crown. He knocks 3 times. The doors are opened, and he delivers the summons. The door shutting dates to the period when the relationship between the Crown and the Commons was genuinely contested, when the Commons' independence required specific physical assertion, and when the ritual of refusing the monarch's messenger immediate access was a meaningful constitutional statement rather than a theatrical performance. It remains a theatrical performance, but it is a theatrical performance of something real, the constitutional independence of the Commons from the Crown that was established in the medieval period, and that the ceremony still asserts 700 years later in the specific idiom of the medieval constitutional convention. The jury system is the medieval institution whose consequences are most directly and immediately felt by the largest number of people in the modern world. The right to trial by a jury of one's peers, the specific right that Magna Carta of 1215 enshrined as the foundational protection against arbitrary royal power, is the medieval legal innovation that the common law tradition has carried into the 21st century as one of the most fundamental protections of individual rights. Magna Carta itself, the great charter that King John sealed at Runnymede in 1215 under pressure from his barons, is another medieval survival with direct contemporary relevance. Only 4 clauses of the original Magna Carta remain on the statute books of England and Wales today, but those 4 clauses include the foundational statements of individual liberty that the subsequent 7 centuries of English and American constitutional development have built on. Clause 39. No free man shall be seized, imprisoned, dispossessed, outlawed, exiled, or ruined in any way, nor in any way proceeded against, except by the lawful judgment of his peers and the law of the land, is the specific 13th century sentence that the constitutional tradition of the United States, the United Kingdom, and numerous other countries identifies as the origin of the right to due process. The Supreme Court of the United States in the 21st century still cites Magna Carta. The 13th century English document is cited as authority in the constitutional jurisprudence of the most powerful court in the world's most powerful country, 800 years after the barons of England forced a recalcitrant king to put his seal on it in a meadow by the Thames. The guild system of the medieval period survives in the form of the livery companies of the City of London, the trade organizations that the medieval guilds of the city became over the centuries, maintaining their medieval names and their medieval ceremonies and their medieval governance structures, while their actual economic functions have evolved dramatically. The Worshipful Company of Mercers, the Worshipful Company of Grocers, the Worshipful Company of Drapers. The names on the list of the City of London's livery companies are the names of the medieval trades whose guilds the companies descend from, and the specific precedence order among the 12 great livery companies was established in 1515 and has not changed. The livery companies are not merely ceremonial. They fund substantial charitable and educational programs. They maintain the livery schools, whose medieval origins are visible in their names and their constitutions, and they participate in the governance of the City of London in ways that give them genuine institutional significance in the modern world. But they operate under governance structures, the Court of Assistants, the Master and Wardens, the liverymen, and the freemen. That are the medieval guild governance structures, maintained through the centuries with the specific fidelity to form that the City of London's constitutional conservatism produces. The freedom of the City of London, the admission to the freedom that was the medieval prerequisite for trading in the city, and that remains today a ceremonial honor bestowed on distinguished individuals and the children of freemen, is another medieval institution that has made the transition from practical necessity to ceremonial honor without losing its formal existence. The freedom can be obtained today by servitude, completing an apprenticeship with a livery company, by patrimony, being the child of a freeman, by redemption, paying a fee, or by presentation, being honored with the freedom by a livery company. The 4 methods are the 4 medieval methods, unchanged in their formal structure across the centuries. The Inns of Court, the 4 legal institutions in London through which barristers in England and Wales are trained and called to the bar, are medieval institutions whose physical premises, governance structures, and educational traditions reflect their 14th century origins. Lincoln's Inn, Gray's Inn, the Inner Temple, and the Middle Temple occupy the same physical locations in central London that they have occupied since the medieval period, in buildings that mix medieval originals with later additions, governed by their benchers in the structure that the medieval inns established, maintaining the specific dining requirement, the eating of a set number of formal dinners in the inn before being called to the bar, that dates to the medieval educational tradition in which shared meals were a primary mechanism of professional socialization. The requirement to eat dinners is one of the more charming survivals. The modern barrister in training is required to keep terms, to attend a specific number of qualifying sessions that can include formal dinners, educational events, and other inactivities as a condition of being called to the bar. The formal dinner requirement is a direct survival of the medieval educational tradition in which the inn's hall was the space where the students of the law learned from the senior lawyers through the specific social mechanism of shared meals and the conversation that shared meals produced. The meal was the seminar. The table was the classroom. Chapter 4. The Monarchy, the medieval institution that is still running, and the specific medieval rules. It still follows the King of England cannot enter the House of Commons. This is not a matter of protocol or courtesy. It is a constitutional rule, and it has been a constitutional rule since 1642, when Charles I walked into the House of Commons with an armed guard to arrest 5 members of Parliament and found famously that the birds have flown. The subsequent constitutional settlement between Crown and Parliament, that the Civil War and the Glorious Revolution produced, made the Commons' independence from the Crown a foundational principle of the English Constitution, and the physical manifestation of that principle, the bar of the House of Commons, beyond which the monarch cannot pass, has been maintained ever since. But the rule has medieval roots that run deeper than 1642. The relationship between the medieval crown and the medieval parliament was the relationship in which the constitutional principle was first articulated. The tension between royal authority and parliamentary representation first made explicit, and the specific rules about what the king could and could not do first, written into the constitutional practice that the subsequent centuries formalized. The 1642 incident was the dramatic crystallization of a conflict that had been developing since the 13th century, and the constitutional rule it produced was the formalization of medieval constitutional principles that had been contested for 400 years before. Charles walked through the Commons door. The coronation ceremony of the British monarch is perhaps the most comprehensively medieval of all the surviving medieval institutions, in the specific sense that the ceremony performed at Westminster Abbey for the coronation of the current monarch follows a ritual whose core elements were established in the 10th century and have been maintained with extraordinary fidelity through the subsequent 1,000 years. The order of service for the coronation of Charles III in 2023 would have been recognizable in its essential structure to the advisors who organized the coronation of Edgar at Bath in 973, when the ceremony that Archbishop Dunstan designed became the template that all subsequent English coronations have followed. The anointing is the medieval core of the ceremony, the specific sacred act that transforms the person into the monarch in the medieval understanding of sacred kingship. The anointing oil applied to the head, the hands, and the breast of the new sovereign by the Archbishop of Canterbury is the specific ritual that the medieval church developed as the mechanism by which the divine sanction for royal authority was conferred on the individual. It is the element of the coronation that the monarch specifically requested be shielded from the cameras at the 2023 coronation. The most ancient, most sacred element, maintained as private in the sense of not for public display, as it has been maintained as private for centuries. The coronation regalia, the crown jewels, the specific objects used in the ceremony, include items whose medieval origins are directly operative in their function. The sovereign's orb, the sovereign's scepter, the ampulla that holds the consecrated oil, the coronation spoon that applies it. These are medieval objects being used in a medieval ceremony in the 21st century. Their specific forms and their specific functions unchanged from their medieval origins. The ampulla, the golden eagle-shaped vessel that contains the consecrated oil, and the coronation spoon are the oldest items in the crown jewels, and the only items to have survived the melting down of the crown jewels ordered by Parliament after the execution of Charles I in 1649. Oliver Cromwell's Commonwealth sold or melted the other medieval regalia as the symbols of the royal tyranny that the Commonwealth had abolished. The ampulla and the coronation spoon survived, apparently hidden or purchased by someone who anticipated the monarchy's eventual restoration, when Charles II was restored to the throne in 1660 and new regalia was made for his coronation. The ampulla and the spoon, the medieval originals, were returned to use. The king's champion, the individual who rides into the coronation banquet to challenge anyone who disputes the monarch's right to the throne. is a medieval ceremony whose origins lie in the feudal obligation of the de Marmion family, who held their manor in Lincolnshire by the specific tenure condition that they would provide the champion service at each coronation. The de Marmion family eventually failed in the male line, and the right passed through inheritance to the de Moquet family, who have been the king's champions since the 14th century. The ceremony at the coronation banquet was last performed at the coronation of George IV in 1821. The subsequent coronations have not included the banquet, and therefore have not included the champion's challenge. But the de Moquet family is still the king's champion. The hereditary office created in the feudal period is still held, technically, by the hereditary heirs of the original grant. The royal peculiars, the churches that are directly under the jurisdiction of the monarch rather than under any bishop, are a medieval constitutional arrangement whose survival reflects the specific relationship between the crown and the church that the medieval English Constitution developed. Westminster Abbey is the most famous royal peculiar, exempt from episcopal oversight, governed by its dean and chapter, accountable directly to the monarch. The medieval logic that certain churches were sufficiently important to the crown's religious and political functions to require direct royal oversight rather than episcopal governance is the logic that is still operative in the 21st century governance of Westminster Abbey. The concept of the monarch as the fountain of honor, the sole source from which honors and titles flow, the specific medieval principle that only the king could create noble titles and grant coats of arms, remains operative in the modern constitutional monarchy. The College of Arms, the heraldic authority of England, Wales, and Northern Ireland, was incorporated by royal charter in 1484 and remains the authority that grants and registers coats of arms today. You cannot simply adopt a coat of arms in England. You must apply to the College of Arms. The application is considered by the heralds, and the grant, if approved, is made by the Earl Marshal on behalf of the Crown. The medieval principle that heraldry was a form of royal authority, that the visual language of noble identity was the Crown's to grant and regulate, is still operative in the 21st century in the specific institutional form of the College of Arms. The Lords, spiritual, the bishops of the Church of England who sit in the House of Lords by virtue of their episcopal office, are a medieval survival whose constitutional significance is genuinely substantial. The presence of the bishops in the House of Lords dates to the medieval period, when the church was one of the two estates of the realm alongside the temporal lords, and the bishop's right to participate in the legislative process was the constitutional expression of the church's position as a governing institution alongside the crown and the baronage. The disestablishment of the Church of England, the formal separation of church and state that the constitutional reform movement has periodically advocated, would require removing the lords spiritual from the lords, among other changes, and the specific political difficulty of achieving this has preserved the medieval constitutional arrangement into the 21st century. Bishops still sit in the House of Lords. The Church of England is still the established church. The medieval relationship between crown and church, though dramatically transformed from its original form, is still institutionally operative in the governance structure of the United Kingdom. The doctrine of the divine right of kings, the medieval theological principle that the king's authority derived directly from God and was therefore not subject to human limitation, is not, obviously, the operative constitutional principle of the modern monarchy. The constitutional monarchy of the 21st century is the product of the specific revolutions, Carbon, constitutional, political, and social, that dismantled the absolute monarchy of the medieval period and replaced it with the parliamentary democracy that the modern United Kingdom operates. But the ceremonial residue of the divine right principle is still present in the coronation ceremony, in the specific religious language of the anointing and the oath, in the defender of the faith title that Henry VIII acquired from the Pope in 1521, and that British monarchs still bear, in the prayers said in churches throughout the country for the monarch's well-being as a specifically religious obligation. The medieval understanding of the monarch as the sacred intermediary between the divine order and the human community is not the modern understanding, but its ceremonial expression is preserved in the institutions that the modern monarchy maintains. The ceremony says something about the sacred nature of royal authority, even as the constitutional reality has entirely replaced the medieval political theology that gave the ceremony its original meaning. Chapter 5. The Church, the medieval religious institutions and rule that survived the Reformation and everything else. The Church of England was created to solve a divorce problem. This is a slight oversimplification of the complex theological, political, and personal factors that produced the English Reformation under Henry VIII, but it captures the specific, personal urgency that drove the particular form that the English break with Rome took. Henry VIII wanted to annul his marriage to Catherine of Aragon. The Pope wouldn't grant the annulment, and the specific solution Henry arrived at, declaring himself the supreme head of the Church of England, and thereby his own ecclesiastical authority, was the solution that the medieval constitutional tradition made possible, because the medieval relationship between Crown and Church in England had always included the specific tension between royal authority and papal authority that the Reformation resolved in favor of the Crown. The Church of England that Henry VIII created retained an extraordinary proportion of the medieval Catholic Church's institutional structure, rituals, and governance, the preservation of the episcopate, the retention of the cathedral chapters, the maintenance of much of the liturgical calendar, the continuation of the monastic orders in modified form. Because the Reformation in England was a constitutional revolution rather than a theological one in its initial form, and the institution that resulted was the medieval Catholic Church, with the Pope replaced by the Crown, rather than the stripped-down, theologically transformed church that the Protestant reformers on the continent were building. The result is a Church of England whose institutional structures, whose physical fabric, whose governance arrangements, and whose liturgical traditions are substantially medieval in their origins and in some cases in their specific content. The cathedrals, the great medieval church buildings that the Reformation failed to demolish because they were too large, too beautiful, too embedded in the landscape, and too useful as seats of episcopal authority, are the most visible expression of this continuity. Medieval buildings in which the medieval liturgical functions are still performed, in a modified but recognizable form every day. The cathedral chapters, the bodies of canons who collectively govern the cathedral, and who have the specific institutional structure of the medieval chapter, are medieval institutions whose governance arrangements are defined by medieval statutes and medieval custom. The dean and chapter of an English cathedral operate under governance rules that were established in the medieval period, amended by the various acts of Parliament that the Reformation and the subsequent centuries of church reform produced, but still recognizable as the medieval institutional form. The tithe, the medieval obligation to pay 1/10 of agricultural produce to the church, is a genuine medieval survival whose final abolition in its original form came only in the 20th century. The Tithe Commutation Act of 1836 converted the payment of actual produce to a monetary equivalent, and the Tithe Act of 1936 converted the monetary payment into a land charge, and the Finance Act of 1977 redeemed the remaining tithe charges. The tithe as a financial obligation on English land existed in some form from the 8th century until the 1970s. An institution of approximately 1,200 years that the agricultural economy and the social structure of England had organized around before the modern period finally completed its abolition. The benefit of clergy, the medieval legal privilege that allowed clergy to be tried in ecclesiastical courts rather than royal courts, escaping the harsher punishments of the royal system, survived in a modified form into the 19th century. The original privilege, which applied to anyone who could demonstrate literacy and therefore plausibly claim clerical status, was one of the more remarkable expansions of a medieval legal privilege. The ability to read to prove literacy by reading the first verse of Psalm 51, known as the neck verse because it saved the reader from execution, was the specific test that allowed the literate criminal to claim benefit of clergy and thereby avoid hanging, By the 18th century, benefit of clergy had expanded so far from its original clerical purpose that it was essentially a statutory mitigation for first-time offenders who could demonstrate literacy, and the privilege was abolished by the Criminal Law Act of 1827. Nearly 6 centuries after its original medieval formulation, the canonical hours, the medieval monastic system of prayer at fixed intervals through the day and night, whose bells organized the medieval community's time, have left a specific linguistic legacy in the modern English day. The word noon comes from the Latin nona hora, the ninth hour, which in the medieval monastic system was the midday prayer of the office of none. The medieval none was said at the ninth hour after dawn, which in the Roman and medieval counting system was approximately 3 p.m. At some point in the medieval period, the office of none moved earlier in the day. Gradually, through the centuries of monastic practice, the time of the prayer shifted toward midday, and the word noon followed the practice, eventually settling at 12 o'clock where it has remained. The church courts, the ecclesiastical courts that the medieval church maintained for the adjudication of matters within their jurisdiction, still exist in the Church of England, operating under a system that is ultimately derived from the medieval canon law system, modified by centuries of parliamentary legislation and church reform. The faculty, jurisdiction courts, which deal with matters affecting church buildings and their contents, and the consistory courts, which deal with disciplinary matters involving clergy, are the modern descendants of the medieval ecclesiastical court system. The probate jurisdiction, the authority to prove wills and administer estates of the dead, was an ecclesiastical court jurisdiction throughout the medieval period, and remained so until the Probate Act of 1857, which transferred the jurisdiction to the civil court system. For approximately 500 years, the proving of a will was an ecclesiastical process conducted by the church courts because the medieval church had successfully claimed jurisdiction over all matters relating to the dead and their affairs. The specific institutional memory of this jurisdiction is preserved in the records of the ecclesiastical courts, which are among the most important genealogical and social history sources for the pre-1858 period. The feast days of the Christian calendar, the specific days of the year assigned to the commemoration of saints and sacred events that the medieval church had established, still organize the legal and commercial calendar of the modern world in ways that most people don't notice. The quarter days, Lady Day, Midsummer Day, Michaelmas, and Christmas are the 4 feast days of the medieval liturgical calendar on which rents were traditionally paid. Leases began and ended, contracts were settled, and servants were hired and fired. The quarter days are still used as the basis for some commercial and legal arrangements in England, and they appear in leases and contracts with a frequency that reflects the durability of the medieval calendar in commercial practice. The specific date of the financial year end in the United Kingdom, April 5th, is a medieval survival of unusual specificity. The medieval and early modern financial year began on Lady Day, March 25th, which was the feast of the Annunciation and was treated as the first day of the new year in the medieval English calendar. When Britain adopted the Gregorian calendar in 1752, 11 days were added to correct the accumulated discrepancy between the Julian and Gregorian systems, and the financial year's start date shifted from March 25th to April 5th, 11 days later, where it has remained ever since. The British tax year ends on April 5th because the medieval church celebrated the Annunciation on March 25th. Chapter 6. The money, the medieval financial institutions and concepts that still shape the economy. The pound sterling is approximately 1,200 years old, not the specific banknote you have in your pocket. The note itself is considerably more recent than that, but the unit of account, the specific denomination, the pound that is the basic unit of the British monetary system, has its origins in the medieval monetary system of Charlemagne's Frankish Empire, where the libra, the pound weight of silver, became the foundational unit of the monetary system that spread through medieval Europe. The The pound that the medieval English monetary system adopted was the pound of sterling silver, a specific alloy of silver whose composition the word sterling describes, from which the specific coins called pennies were struck. The relationship between the pound, the shilling, and the penny, the old pre-decimal currency system that the United Kingdom used until 1971, was the medieval relationship of accounting that the Carolingian monetary system had established. 12 pennies to the shilling, 20 shillings to the pound. The decimal system that replaced it in 1971 brought the currency into alignment with the mathematical convenience that the rest of the world had largely adopted, but the pound itself, the unit, the name, the symbol, survived from the medieval origin. The Bank of England, founded in 1694, is not medieval, but the institutions it replaced and the legal framework within which it operates have medieval roots. The concept of the exchequer, the royal treasury, and the accounting system that managed the medieval crown's finances gave the English fiscal system its institutional foundation, and the specific accounting methods of the medieval exchequer are the institutional ancestors of the modern treasury. The exchequer itself, named for the checkered cloth on which the medieval accountants arranged the counters that represented the financial figures being calculated, is a medieval financial institution whose name has survived into the modern day in the office of the Chancellor of the Exchequer, the British equivalent of the Finance Minister. The Chancellor of the Exchequer is a medieval title for a modern office, and the budget that the Chancellor presents to Parliament each year in the medieval leather dispatch box. The specific red box of the budget has been used since 1860, but the institution of the Chancellor presenting accounts to Parliament is the medieval institutional practice, is the continuity of the medieval financial governance system in the modern democratic framework. The concept of the public debt, the specific financial instrument through which governments borrow money from the public, has medieval origins in the Italian city-states' development of the funded debt, the Monte Comune, through which the cities of Florence and Genoa and Venice raised money from their citizens against the promise of interest payments. The medieval Italian financial innovators, the bankers of Florence and the merchants of Venice, were the specific inventors of the financial instruments that the modern public debt system descends from. Usury, the charging of interest on loans, was prohibited by the medieval church as a sin on the theological grounds that money itself was sterile and that charging for its use was therefore unjust. The specific medieval prohibition on usury shaped the development of financial instruments through the medieval and early modern period, driving the innovation of interest payments disguised as something else. The bill of exchange, the commercial partnership, the various legal structures that the creative minds of the medieval financial community invented to achieve the economic function of lending at interest without triggering the canonical prohibition. The modern financial system's inheritance from this medieval creativity is substantial. The bill of exchange, the instrument of the medieval trade that allowed merchants to transfer money across distances without physically moving it, is the ancestor of the modern check and the modern wire transfer. The commenda, the medieval commercial partnership in which one party provided the capital and another provided the labor, sharing the profits, is the ancestor of the modern limited partnership and the venture capital fund. The insurance contract, developed in medieval Italian commerce to spread the risk of maritime trade, is the ancestor of the modern insurance industry. The guilds of the medieval period established the institutional framework of professional regulation. The idea that a specific trade or profession should be organized by a corporate body with the authority to set standards, admit members, and discipline those who violated the professional code, that the modern professional licensing system descends from. The medieval guild's examination of the journeyman's work before admitting him to full membership is the ancestor of the bar examination, the medical licensing examination, the professional certification that the modern economy requires for entry into a regulated profession. the concept of the corporation, the legal person, the entity distinct from the individuals who compose it, capable of owning property, entering contracts, and continuing to exist after the death of any individual member, was developed in the medieval period by the canon lawyers who were grappling with the legal status of the church itself. The church was a corporate body. It owned property, it entered contracts, it had been in existence for centuries, and would continue to exist after all its current members died. The legal framework for understanding how such an entity could function as a legal person was developed in the medieval canon law, and the concept migrated from the church to the secular world through the development of the municipal corporation, the trading company, and eventually the modern limited company. The limited liability company, the specific corporate form that allows investors to lose only what they have invested without being personally liable for the company's debts, is a 19th century development, but it builds on the medieval corporate concept and on the specific financial innovations of the medieval period that the early modern joint stock companies developed into the institutional form that the 19th century formalized and the 20th century universalized. Chapter 7. The land, the medieval property law, that still determines who owns what. Technically, you don't own your house. If you are a property owner in England or Wales, and the principle applies to a lesser extent in other common law jurisdictions, you do not own the land your house sits on, in the absolute sense that the word own implies in everyday language. You hold it. The technical legal term is that you hold the land in fee simple, and the fee simple is a form of tenure, a way of holding land in relation to the crown, rather than absolute ownership in the civil law sense. This distinction is the medieval distinction between dominium, the absolute ownership of the Roman law tradition, and tenure, the hierarchical land holding of the feudal system. And it is a distinction that the English common law has maintained across 8 centuries of social, economic, and legal transformation. The feudal system, in which all land was ultimately held from the crown, and in which the relationship between the landholder and the crown was defined by the specific services and obligations that the tenure required, was reformed and modified beyond recognition by the Law of Property Act 1925 and the subsequent legislation that modernized the English land law. But the fundamental concept that land in England is held rather than owned, that the tenure rather than the dominium is the legal form of the relationship between the person and the land, survives in the modern law. The freehold and the leasehold, the 2 primary forms of land holding in England and Wales, are medieval legal concepts. The freehold tenure is the medieval free tenure, the holding that carries no specific service obligations to the superior lord and that the holder can dispose of freely. The leasehold is the medieval leasehold, the holding for a term of years that the medieval landowner granted to the tenant as a way of raising income from the land without permanently alienating it. The leasehold in particular is a medieval institution with very contemporary consequences, as the residents of leasehold apartments in England and Wales have discovered to their significant financial and legal disadvantage. The specific problems of the leasehold system, the ground rents, the service charges, the permission fees, the decreasing value of the remaining lease term, the relationship between the leaseholder and the freeholder that the medieval concept defines, are the problems of a medieval land tenure system being applied to the 21st century property market in ways that the medieval inventors of the system could not have anticipated, and that the 21st century property owners find extremely frustrating. The Law Commission of England and Wales has been recommending reform of the leasehold system for years, and the specific reforms are being slowly implemented. But the underlying medieval concept is proving durable in ways that the reformers find challenging, partly because so much of the modern property market and so much of the existing property law is built on the medieval foundation that changing it requires changing things that the modern world has built on top of it. The land registry, the system of recording ownership, of land titles that the Land Registration Act of 2002 made compulsory for all land. In England and Wales is a modern institution, but the land law it records is substantially medieval. The titles recorded in the land registry are titles defined by medieval concepts of tenure and medieval definitions of the rights and obligations that attach to the land, formalized by centuries of conveyancing practice and court decisions that have accumulated on the medieval foundation. The common land, the land that the medieval community held in common, on which the commoners had specific rights of grazing and gathering, and cutting that the feudal system defined and the manorial courts enforced, is a medieval institution whose survival into the modern world has been one of the more contested aspects of the long history of English land law. The enclosures, the centuries-long process by which the common lands of medieval England were enclosed and converted to private ownership, reduced the common land from a substantial proportion of the English landscape to a small remnant. But the common land that survived the enclosures is still common land, still subject to the rights of the registered commoners, still governed by the Commons Act framework that preserves the medieval institution in the modern legal form. The rights of common, the specific medieval rights of the commoner to use the common land, are still registered and still operative. The right of common of pasture, to graze a specific number of animals on the common, the right of estovers, to collect wood from the common for fuel, the right of turbary, to cut peat from the common for fuel, the right of piscary, to fish in the common waters. These are the medieval names for medieval rights that are still registered against specific commons in England and Wales, and that the courts will enforce against the landowner who tries to interfere with them. The village green, the specific piece of land at the center of the English village that the community has historically used for recreation and assembly, is protected today by the registration system that the Commons Registration Act of 1965 established, which records village greens as a specific legal category of land protected from development. The protection reflects the medieval communal use of the space, the specific understanding that the village green was held in common for the community's use. Codified in modern legal form, protecting the medieval space with the modern legal instrument. The manorial rights, the rights that the lord of the manor held under the feudal system, including the rights to minerals, sporting rights, and the various other perquisites of the medieval lordship, survive in attenuated form in the modern law. When the major land reforms of the 20th century swept away most of the remnants of the feudal system, the manorial rights were specifically preserved as a category of rights capable of surviving the sale of the manor and existing independently of it. The result is that in some parts of England, the rights to the minerals under a piece of land, or the right to hold a market, or the right to take toll on certain activities are still owned by the lord of the manor, whose title traces back to the medieval grant. And the modern landowner who discovers this is discovering a medieval institution with very contemporary consequences. 1019 A. M. Chapter 8. The Rules of War. How medieval chivalry became international law. The Geneva Conventions are the descendant of the medieval laws of chivalry. This statement requires unpacking, because the connection between the 14th century code of knightly conduct and the 20th century international treaties governing the treatment of prisoners of war and the protection of civilians is not obvious until you trace the specific intellectual history that connects them. The connection runs through the medieval law of arms, the specific body of customary law that the medieval military community developed for the regulation of warfare, through the early modern natural law theorists who systematized the medieval customs into the theory of the law of nations, and from there to the 19th and 20th century international law codification that produced the treaties that govern armed conflict today. The medieval law of arms was the specific, practically operative body of rules that governed warfare in the medieval period, enforced through the courts of chivalry that adjudicated disputes arising from the conduct of war. The court of chivalry, the English court that heard disputes about matters of honor, heraldry, and the conduct of war, was a functioning legal institution of the medieval period whose jurisdiction included the adjudication of ransom disputes, the settlement of claims about the right to take prisoners, and the enforcement of the rules that the medieval military community had developed for the regulation of the violence that was its primary occupation. The ransom system was one of the most important practical expressions of the medieval laws of war, and its operation tells you something specific about how those laws worked. The medieval convention that a captured knight was entitled to be ransomed rather than executed, that the surrender of the armored warrior carried with it the specific obligation of the captor to hold the prisoner for ransom rather than kill him, was not merely a chivalric ideal. It was a financially important convention whose violation carried serious legal consequences, adjudicated in the courts of chivalry by the heralds and the military judges who enforced the laws of war in the medieval period. The ransom system applied to knights, to the armored mounted warriors who were the expensive, specialized military assets of the medieval army. And its protections did not extend to the common soldiers, the infantry, the non-armored combatants who could be killed or enslaved without the specific legal protection that the knight's status provided. This class distinction in the laws of war, the differential treatment of combatants based on their status rather than simply on their combatant status, is one of the medieval law of arms' more troubling features, and it is a feature that the subsequent development of the laws of war has been slowly addressing through the principle of equal treatment for all combatants, regardless of rank. The non-combatant protection that the medieval laws of war included was limited and inconsistently applied, but it existed. The concept of the truce of God, the ecclesiastical prohibition on warfare, on specific holy days, and during specific seasons of the church year, and the peace of God, the ecclesiastical prohibition on attacks on specific categories of non-combatants, including clergy, pilgrims, and agricultural workers, were medieval church attempts to limit the violence of warfare through the application of religious authority to the conduct of military operations. The enforcement was imperfect. The principle that warfare should be conducted within limits that protected certain people and certain places from the violence of armed conflict is the principle that the modern laws of war attempt to apply with better enforcement mechanisms. Christine de Pizan's The Book of the Body of Polity and The Book of Deeds of Arms and of Chivalry, written in the early 15th century by one of the most remarkable writers of the medieval period, codified the laws of war in a form that the subsequent tradition of the law of nations built on. Christine's systematic treatment of the customs of war, drawing on the Roman law tradition and the medieval customary law, provided the framework that the 16th and 17th century natural lawyers, Hugo Grotius, Francisco de Vitoria, Alberico Gentili, used as the foundation for their development of the theory of international law. Hugo Grotius's De Jure Belli ac Pacius, on the law of war and peace, published in 1625, is the foundational text of modern international law, and it is explicitly built on the medieval legal tradition. Grotius acknowledged his debt to the medieval canonists and the medieval law of arms, and the specific principles he articulated, the distinction between just and unjust wars, the protection of non-combatants, the treatment of prisoners, the binding nature of treaties, are the medieval principles, systematized into the natural law framework that the early modern period developed. The Geneva Conventions, the 1864, 1906, 1929, and 1949 treaties that codify the modern laws of armed conflict are the codification of the principles that Grotius systematized from the medieval tradition. The protection of the wounded, the treatment of prisoners of war, the protection of civilians, these are the principles that trace their intellectual lineage through the natural law tradition back to the medieval law of arms, and from there to the specific practical rules that the medieval military community had developed for the regulation of warfare. The International Court of Justice and the International Criminal Court, the modern institutions that enforce the laws of armed conflict and prosecute those who violate them. are the modern institutional equivalents of the courts of chivalry that enforce the medieval law of arms. The specific jurisdiction is different. The enforcement mechanisms are different. The theoretical framework is different. But the fundamental idea that warfare is conducted within a framework of rules that constitute a form of law, and that violations of those rules can be adjudicated by a court, is the medieval idea, surviving in the modern institutional form. The specific crime of perfidy, the violation of the specific good faith protections that the laws of war provide, particularly the prohibition on attacking under the protection of the white flag of truce, is a medieval concept that the modern laws of war have preserved with the specific language of the medieval origin. The white flag of truce, the signal that the bearer is not a combatant but an emissary seeking negotiation, is a medieval convention whose violation was treated as a serious breach of the laws of war in the medieval period, and whose violation is still treated as a war crime under the modern Geneva Conventions. Chapter 9. The Universities. The medieval institutions that are still teaching. Oxford is approximately 900 years old. The specific date of Oxford University's founding is uncertain. The teaching that eventually became Oxford University was happening by the late 11th century, was disrupted and resumed several times, and was formalized into an institution recognizable as a university in the early 13th century. Cambridge was founded in 1209, according to the tradition that traces its origin to the scholars who left Oxford after a dispute with the town. The specific town and gown conflict that the medieval university's uneasy relationship with its host community produced in the specific form of scholars picking up and walking to the next town. The universities that the medieval period created, Oxford, Cambridge, Bologna, Paris, Salamanca, Prague, Vienna, Heidelberg, and the dozens of others that the late medieval period established across Europe, are still operating. The same institutions in the same cities, in some cases in buildings that have been continuously in educational use since the medieval period, teaching in ways that would be recognizable to the medieval scholars who established them, governed by statutes and conventions whose medieval origins are sometimes still directly legible in the modern institutional arrangements. The medieval university was an institution of a specific type, the universitas, the corporate body of scholars and students that the medieval canon law recognized as a legal person capable of holding property, making rules, and governing its own affairs, with a degree of autonomy from the surrounding secular and ecclesiastical authorities. The medieval university's self-governance, its claim to determine its own curriculum, its own membership, its own internal discipline, was the specific institutional autonomy that made the university a durable institution capable of surviving the political changes of the subsequent centuries. The degree, the academic qualification that the university awarded to mark the successful completion of study, is a medieval invention. The bachelor's degree, the master's degree, and the doctorate are the 3 degrees of the medieval academic ladder, whose names and whose structural relationship to each other are unchanged from the medieval system. The bachelor completed the first stage of study. The master, the magister, the teacher, completed the second stage and was licensed to teach. The doctor, the title that originally applied to the higher degrees in theology, law, and medicine, the 3 learned professions of the medieval university, completed the highest level. The specific ceremonies of the degree conferral, the formal academic ceremony, the academic dress, the language of the conferral, are medieval survivals maintained with the specific fidelity to form that academic institutions have shown toward their own traditions. The academic gown is the medieval clerical robe that the scholars of the medieval university wore, in the specific idiom of the clerical dress of the medieval church from which the university emerged. The hood is the medieval hood that the gown-wearing scholar pulled up against the cold of the unheated medieval lecture hall. The mortarboard is a later development, but the cap, as an element of academic dress, has medieval origins. The specific language of degree conferral, at Oxford, still partially in Latin, is the language of the medieval university. The Oxford degree ceremony includes the specific Latin formula by which the vice-chancellor confers the degree, in the language of the medieval institution that has not changed its ceremonial language in the centuries since the Latin of the educated class was replaced by the vernacular languages of European academic life. The tutorial system at Oxford and Cambridge, the specific educational method in which the student meets individually or in very small groups with the academic tutor, who assigns reading, hears the student's essay, and conducts the specific critical conversation that the tutorial produces, is a medieval educational method. The lecture was the medieval university's primary mode of instruction. The reading aloud of the text, the commentary on the text, the disputation about the text's meaning, and the tutorial's individual supervision is the development of the medieval personal instruction that the scholar received from the master in the intimate educational context of the medieval studium. The disputatio, the formal academic debate in which the scholar defended a thesis against the objections of the opponent, in the specific format of the medieval logical disputation, is the ancestor of the modern doctoral viva, the oral examination in which the PhD candidate defends their thesis before the examining panel. The specific format of the viva, the candidate presents their work, the examiners object, the candidate responds, is the medieval disputatio format, maintained in the modern academic tradition as the specific test of the candidate's ability to defend their intellectual position under pressure. The specific governance of Oxford and Cambridge, the congregation at Oxford, the Regent House at Cambridge, the bodies of academics who are the ultimate governing authorities of the university, are medieval governance structures whose continuity through the centuries reflects the specific self-governing character of the medieval universitas. The medieval university's claim to govern itself through the assembled academics, rather than through an external authority, is the claim that Oxford and Cambridge still maintain in the specific form of the academic governance bodies that predate the modern university management structures that have grown up around them. The Bodleian Library at Oxford, founded in 1602, but refounded on the basis of the medieval Duke Humphrey's Library that had been established in the 15th century, is one of the legal deposit libraries of the United Kingdom, entitled to a copy of every book published in the country. The legal deposit requirement that a copy of every publication be deposited in specific libraries is a system whose origins lie in the privileges granted to the early modern university libraries, which are themselves the continuation of the medieval monastic library tradition in which the preservation of texts was a religious and scholarly obligation. Chapter 10. The Marketplace. The medieval trading rules and institutions still operating. You need a charter to hold a market. In medieval England, the right to hold a market, to gather sellers and buyers in a specific place on a specific day for the purpose of trade, was a royal grant, a privilege conferred by the crown in exchange for the payment of fees and the performance of the specific obligations that the market charter required. The market charter was the specific document that legitimized the market, that gave the market's holder the right to collect tolls from the traders, that protected the market from competition by prohibiting the establishment of new markets within a specific radius of the existing one. These market charters still exist. The specific grants made by medieval kings, by Henry III, by Edward I, by their predecessors and successors, are still the legal basis on which certain English markets operate today. The market at Shrewsbury has operated on a weekly basis since its charter was granted in the 13th century. The market at Winchester has medieval charter rights that still define its legal status. The Statute of Winchester of 1285, the medieval law that regulated the conduct of markets and fairs, contains provisions that are still cited in the regulation of market trading. The right of market, the medieval grant that gave the holder the exclusive right to hold a market in a specific location, is still a property right capable of being owned, transferred, and enforced. The courts of England and Wales will still hear cases about market rights, and the medieval charters are still admissible, evidence of those rights. The medieval king's grant is still legally operative. in the specific sense that a court will give effect to it in the resolution of a modern commercial dispute about the right to trade in a specific location. The fair, the larger periodic gathering of traders that was distinguished from the weekly market by its greater scale and its different legal regime, was another medieval institution whose legal framework is still operative in some cases. The Statute of Merchants of 1285, another medieval commercial law, established the specific legal framework for the enforcement of commercial debts at fairs, and the pie powder courts, the courts of dusty feet, named for the dusty feet of the traveling. Merchants who appeared before them were the specific rapid justice courts that the fairs maintained for the resolution of commercial disputes arising during the fair. The pie powder court has not been formally abolished in English law. It exists, technically, as a legal institution. The last pie powder court to sit in England is believed to have been at the Hemel Hempstead Fair in 1898, but the legal authority for the court's existence has not been specifically repealed. The medieval court for resolving disputes between market traders is, in principle, still available for use by anyone holding an ancient fair charter who chooses to convene it. The statute of limitations, the legal rule that time bars the bringing of certain legal claims after a specified period, has medieval origins in the English legal tradition. The medieval statutes that set time limits on the bringing of land claims, the Statute of Limitations of 1623 being the major reforming statute, but, building on earlier medieval provisions, established the framework that the modern limitation periods build on. The specific periods have been updated repeatedly by modern legislation, but the principle that there is a point after which a legal claim cannot be brought, because the passage of time creates the legitimate expectation that the old claim has been abandoned, is the medieval principle. The weights and measures, the specific units of measurement that commercial transactions use, and that the law requires to be accurate, have medieval origins in the English system. The avoirdupois system of weights, the system of ounces, pounds, and hundredweights that the English commercial tradition used for the measurement of bulk commodities, developed in the medieval period from the medieval wool trade, which required standardized weights for the measurement of the wool clip that was England's most important export commodity. The word avoirdupois is the medieval French for goods of weight, the specific phrase used for the bulk commodity trade, in which the wool trade was the most important element. The hallmarking system, the system of marks applied to precious metal objects to certify their purity, is a medieval institution still operating in the United Kingdom through the assay offices that the medieval guildsmiths established. The assay office in London, the Goldsmiths Company's assay operation at Goldsmiths Hall, from which the word hallmark derives, has been testing the purity of gold and silver objects and applying the specific marks that certify their composition since 1300. The specific marks, the standard mark showing the metal and its purity, the date letter, the assay office mark, are a medieval system of consumer protection still operating in the 21st century. The hallmark on a gold ring is the descendant of the medieval guild's mark, the specific certification that the Goldsmiths Company applied to guarantee the quality of the metal object in the specific context of the medieval guild's quality control function. The consumer who buys a hallmarked gold ring in England today is benefiting from a certification system that the 14th century Goldsmiths Guild established and that has operated continuously for 700 years. Chapter 11. The strange specifics, the most bizarre individual medieval rules that survived now for the truly strange ones. The ones that make the legal historians laugh. The ones that appear in the weird laws lists that circulate online. The ones that are genuinely inexplicable without the specific medieval context that produced them and that are genuinely baffling with it. These are not the grand institutional survivals of Parliament and the common law. These are the specific, individual, inexplicably durable rules that fell through the gaps of the reform process and landed in the 21st century still technically operative. In the United Kingdom, It is technically illegal to handle a salmon in suspicious circumstances. The Salmon Act of 1986, which is emphatically not a medieval statute, it is entirely modern, contains the specific provision that a person who receives or disposes of any salmon in circumstances where it is reasonable to infer that a relevant offense has been committed is guilty of an offense. The specific provision is not the bizarre element here. The bizarre element is that this is the modern codification of the medieval salmon law. The specific detailed regulation of salmon fishing that the medieval period developed as one of its most elaborate bodies of commercial and environmental regulation. The medieval salmon laws, the specific provisions about when, where, how, and by whom salmon could be fished, are among the oldest environmental regulations in English legal history, and their survival in modified form through the 1986 Act is the specific continuity of the medieval tradition of treating salmon as a specially protected commercial species whose regulation required the detailed legal framework that the medieval fishing industry developed. In Scotland, it is still the law that you must allow a stranger to use your bathroom if they need to. This specific claim circulates in the popular tradition of weird Scottish laws, and its specific legal basis is disputed. The precise statute that is cited varies in different accounts, and the enforcement of this alleged rule in the 21st century is essentially non-existent, but the principle behind it, that the householder has certain obligations of hospitality to the traveler that can be legally enforced, is a medieval principle, embedded in the medieval understanding that the duty of hospitality was not merely a social obligation, but a legal one, enforced by the community through the same informal mechanisms that enforce the other social obligations of the medieval village. The right to graze geese on certain English commons, the specific right of common for geese that is registered against some ancient commons, is a medieval right still enforceable in the modern courts. The person whose ancestor registered the right to graze 12 geese on the local common in the 15th century, and whose family has maintained the registration through the intervening centuries, has the legal right to put 12 geese on that common today, and the commoner's court will enforce that right against the landowner who obstructs it. The specific number of geese specified in the medieval registration is the specific number the modern registration retains, not approximately 12 geese, not up to a dozen geese, 12 geese. The medieval specificity of the agricultural right has been preserved in its modern legal form with the same precision that the medieval grant established, because the common law's respect for historical grants extends to the specific numerical details of those grants. The City of London has a medieval rule, still in the city's constitutional arrangements, that the aldermen who sit in the Court of Aldermen hold their positions for life, subject to specific grounds for removal. The modern aldermanic term has been introduced as a reform, but the constitutional position of the alderman in the city's governance retains aspects of the medieval original, in which the alderman was a senior figure of the ward, whose position carried the permanence that the medieval concept of office holding implied. The beefeaters, the yeoman warders of the Tower of London, are required by their conditions of service to live within the Tower of London. The medieval castle's requirement that its garrison live within the walls, the specific operational requirement of the medieval fortification that its defenders be continuously present and ready, is maintained in the 21st century employment conditions of the Tower's ceremonial guards. The beefeaters and their families live in the specific apartments within the Tower walls, in the medieval tradition of the garrison living within the fortification, and the community of the Tower, with its small children who grow up within medieval walls, and its residents who apply to a very specific housing waiting list, is the continuation of the medieval castle community in the modern residential form. The right of the Lord Mayor of London to inspect the body of a dead whale found in the Thames. The specific provision that whales and sturgeons found in the Thames within the city's jurisdiction are the property of the Crown, but that the Lord Mayor has the right of inspection, is a medieval provisions arising from the medieval definition of these species as royal fish, the fish reserved for the monarch's table. The provision is still operative. When a whale was found in the Thames in 2006, the medieval provision was technically applicable. The whale was royal property, and the Port of London Authority and the relevant authorities managed the situation within the framework of a rule that had been written when the Thames was a rather different environment. The specific provision that the monarch must approve the appointment of the Archbishop of Canterbury, that the Prime Minister presents 2 names to the monarch, and the monarch formally appoints one of them, is the modern form of the medieval investiture controversy. The specific conflict between the Crown and the Church about who had the authority to appoint bishops, the investiture controversy that occupied the medieval papacy and the medieval monarchies of Europe from the 11th to the 13th centuries, the conflict between Henry IV and Pope Gregory VII, between Henry I of England and Archbishop Anselm, was the struggle to determine whether the king or the pope had the authority to invest bishops with their spiritual offices. The specific compromise that the English crown and the church reached, the Concordat of London of 1107, which settled the English version of the controversy by separating the ecclesiastical investiture from the secular homage, is the ancestor of the modern arrangement in which the crown formally appoints the archbishop, but does so through the process of consultation that the church's own nomination process determines. The medieval compromise between royal and ecclesiastical authority is still operative in the specific constitutional form of the Prime Minister's nomination and the monarch's appointment. The right of the Duchy of Cornwall, the estate held by the Prince of Wales as heir to the throne, to the treasure of the sea and the swans on the rivers within its territory, is a medieval right still maintained in the duchy's constitutive documents. The Duchy of Cornwall was created in 1337 by Edward III for his son, the Black Prince, and the specific medieval rights granted to the duchy in its foundational charter are still part of the duchy's constitutional position. The Duchy of Lancaster, the estate held by the monarch personally rather than as sovereign, maintains a similar medieval constitutional position, with rights and privileges that trace their origin to the specific medieval grant, and that have been maintained through the centuries by the specific royal commitment to preserving the duchy's constitutional integrity. The specific rule that the Lord Warden of the Cinque Ports, a medieval office created to manage the defense of the 5 ports of the English Channel coast, has the right to all flotsam, jetsam, and wreck within his jurisdiction, is a medieval property right that the surviving documentation of the Cinque Ports Confederation preserves. The Cinque Ports Confederation, the association of Dover, Hastings, Hythe, New Romney, and Sandwich with the 2 ancient towns of Winchelsea and Rye and their attached limbs, was the medieval naval and administrative arrangement by which the English crown managed the channel ports in exchange for ship service obligations. The Lord Warden of the Cinque Ports is still appointed, with the specific ceremony and the specific rights that the medieval office carried. Chapter 12. The language, the medieval words and phrases you use every day without knowing it. You are speaking medieval English right now. Not entirely, obviously. The full Middle English of Chaucer's Canterbury Tales would require a dictionary and considerable patience before it became comprehensible to the modern reader, and the Old English of Beowulf is, to all practical purposes, a foreign language to anyone who hasn't specifically studied it. But the specific words and phrases and grammatical structures that the medieval period contributed to the English language are present in your daily speech in quantities that would surprise you if you stopped to count them. The legal language is the most obvious surviving stratum of medieval English, and it survives because the common law tradition's respect for precedent extends to the precise language in which the precedent was expressed. The lawyer who says hereinafter, or aforesaid, or notwithstanding, is using the specific vocabulary of the medieval legal document. The formulaic language that the medieval scrivener developed for the precise, unambiguous expression of legal meaning, and that the legal tradition has maintained because changing the specific words risks changing the specific meaning that centuries of judicial interpretation have attached to them. The word mortgage is a medieval French compound. Mortgage, dead pledge, the specific metaphor that the medieval financial tradition applied to the arrangement in which land was pledged as security for a loan. The pledge was dead in the sense that the land produced no income for the pledger while the debt was outstanding, unlike the living pledge, in which the land's income went toward repaying the debt. The medieval metaphor, dead pledge, is the word that the modern homeowner uses when they describe the financial arrangement that is probably the largest single financial commitment of their life. The word attorney, the person who acts on another's behalf in legal matters, is the medieval French word for the person appointed to attend in the place of another, the specific legal appointment that the medieval court system required for the representation of absent parties. The attorney was the person who turned to, the French attorney, the legal business of another, and the specific medieval legal appointment that the word described has been maintained in the English legal tradition as the title for the legal representative. The word fee, in the sense of the payment made for professional services, is the medieval feudal term for the land grant by which the feudal superior compensated the vassal for service. The fee was originally the land itself, the fief, the feudum, and the transition from the land grant to the monetary payment reflects the specific medieval transition from the land-based economy of the early feudal period to the money economy that the commercial revolution of the 12th and 13th centuries produced. You pay a legal fee or a doctor's fee or a service fee using a word whose medieval origin connects the payment to the feudal land grant. The word lord, in its secular sense of the person with authority, the employer, the person of superior status, is the Old English schlafweerd, the loaf ward, the guardian of the bread. The person of authority in the Anglo-Saxon household was the person who controlled the bread, the food supply, and the word that described this authority has survived through 1,000 years of social transformation to describe the person of superior status in the modern idiom. The lord of the manor was, etymologically, the guardian of the bread of the manor's community. The word has forgotten this meaning while preserving its social function. The word lady, the female equivalent, is the Old English hleefdage, the bread kneader, the person who made the bread. The social parallel to the lord's guardianship of the bread was the lady's making of it, and the word that described the woman of the household has preserved the social status while thoroughly forgetting the domestic function that originally generated it. The phrase rule of thumb, the approximate measurement by the first joint of the thumb, is a medieval and early modern craft tradition whose specific origin is debated. The medieval craftsman who used the thumb's breadth as a quick measurement unit was using the specific bodily measurement that the medieval craft tradition found convenient and reliable in the specific absence of standardized measuring instruments. The thumb's breadth varies between individuals, which made it a somewhat unreliable standard by the time the Industrial Revolution required more precision, but the phrase has survived the measurement's replacement. The phrase to pay through the nose, to pay an excessive price, has been connected to the medieval Scandinavian practice of slitting the noses of those who failed to pay the tribute that the Danish invaders imposed on the English population. The Danegeld, whether this specific etymology is correct, is debated by the etymologists, but the phrase's medieval resonance is real, and the specific financial anxiety that the phrase expresses, the fear of the excessive payment extracted under duress, is entirely consistent with the medieval experience of taxation and tribute. The word bedlam, the chaos, the scene of wild confusion, is the contracted form of Bethlehem, the name of the Hospital of St. Mary of Bethlehem in London. The medieval institution, founded in 1247 as a priory and converted into a hospital for the mentally ill in the 14th century. The Bethlehem Royal Hospital, Bedlam, was the specific medieval institution whose conditions were, by later accounts, chaotic enough to give its name to the general concept of chaos. The medieval hospital for the mentally ill became through the specific compression of the English language, the word for any scene of wild disorder, the word curfew, The regulation that requires people to be off the streets after a certain hour is the medieval French couvre-feu, cover the fire, the bell that signaled the time to bank the household fire for the night. The medieval curfew was the practical fire safety measure, the instruction to cover the open hearth fire before sleeping, to prevent the unattended fire from spreading to the timber-framed buildings of the medieval town. The word survived the specific fire safety function and retained the general meaning of the restriction on evening activity that the bell's signal imposed. The word salary, the regular payment for work, is the Latin salarium, the salt money, the specific allowance that the Roman army provided to its soldiers for the purchase of salt, which was a sufficiently valuable commodity in the pre-refrigeration world to constitute a significant component of the working person's compensation. The salt allowance of the Roman soldier has given its name to the monetary compensation of the modern employee. The medieval and ancient tradition of providing specific commodities as compensation encoded in the word that describes the modern paycheck. The word assassin, the person who kills for hire or for political purpose, is the Arabic hashishin, a word that the Crusaders brought back from the medieval Middle East. The specific medieval Islamic sect of the Nizari Ismailis, based in the mountain fortresses of Persia and Syria, became famous in the Crusader tradition for their targeted political killings. The word that the Crusaders used for this group's members was the word that entered the European languages to describe the political killer. The medieval contact between the European military tradition and the Islamic world, in the specific violent context of the Crusades, encoded in a word that the modern language uses without necessarily knowing its medieval origin. The words hazard, checkmate, rook, and bishop in the game of chess are medieval and early medieval Arabic survivals that the game's transmission from the Islamic world to the medieval European world produced. Chess arrived in Europe through the Moorish Spain and the Norman Sicily contacts with the Islamic world, and the specific terms of the game were translated or transliterated from the Arabic in ways that preserved the original term's sounds while losing or transforming their meanings. Checkmate is the Persian Shah Mat, the king is dead. Rook is the Persian Ruk. Bishop is a medieval European replacement for the original piece, the fill, the elephant, that the European tradition replaced with the bishop because the elephant was an unfamiliar piece requiring domestication into the European imaginative vocabulary. The word tournament, the medieval institution of the knightly combat event, and in the modern world, any competitive event is the medieval French tournament, from tourner to turn, describing the specific cavalry maneuver of turning the horses in the confined space of the tournament field. The medieval tournament was the specific military training exercise that the nobility converted into a competitive event with elaborate rules and spectators, and the word that described the turning of the horses in the exercise is the word that the modern world uses for any organized competition. Chapter 13. The food and drink, the medieval rules, institutions, and traditions still governing what you eat. The vintage on the wine label is a medieval institution, not the specific year printed on the specific bottle in front of you. That is, determined by the agricultural calendar that has nothing particularly medieval about it, but the institution of recording the year of the harvest as a quality indicator of organizing the wine trade around the specific vintage as the primary identifier of the wine's character and value is a medieval practice whose origins lie in the specific commercial organization of the medieval wine trade and whose survival in the modern wine industry reflects the extraordinary durability of the medieval commercial categories. The medieval wine trade between Bordeaux and England, the trade that the Plantagenet king's possession of Gascony had made the most important wine trade of the medieval period, was organized around the specific vintage in the specific way that the modern Bordeaux trade still is. The wine merchants of medieval Bristol and London and the wine merchants of medieval Bordeaux were conducting their commerce in the specific idiom of the annual vintage, the specific harvest. the specific quality of the specific year. And the modern Bordeaux trade's obsessive attention to vintage quality and vintage variation is the direct continuation of the medieval commercial tradition. The appellation d'origine contrôlée, the French system of designating the geographic origin of wine and other food products as the primary quality indicator, is a 20th century legal formalization of the medieval commercial tradition that associated specific agricultural products with specific geographic origins. The medieval understanding that the wine from specific vineyards had specific identifiable characters, that the wine of the Cistercian monasteries Clos de Vougeot had specific qualities distinct from the wine of the neighboring vineyard, is the understanding that the modern appellation system formalizes in legal terms. The Cistercian monks were wine innovators. The Cistercian monasteries of Burgundy, established in the 12th century in the specific landscape of the Côte d'Or that has been producing the world's most expensive wine ever since, were the specific institutions that developed the systematic viticulture whose principles the modern Burgundy wine trade still operates by. The Cistercian monks walked their vineyards, tasting the soil, identifying the specific parcels that produced the best wine, and developing the classification of those parcels. The specific clos, the walled vineyard that the Cistercians enclosed to define and protect the specific terroir they had identified, that the modern Burgundy classification system is built on. The Clos de Vougeot, the specific walled vineyard that the Cistercians of the Abbey of Citeaux established in the 12th century, is still producing wine. The specific wall that the medieval monks built around the vineyard is still standing. The wine produced within that wall is still classified as the specific appellation that the medieval enclosure defined, the 21st century. Wine drinker who pays the extraordinary price that a bottle of Clos de Vougeot commands is paying partly for the quality of the wine, and partly for the continuation of the specific medieval institution that the Cistercian wall encloses. The Guild of Pepperers, one of the earliest London guilds documented from the 12th century as the organization of the spice merchants who controlled the London trade in pepper and other spices, is the direct ancestor of the Worshipful Company of Grocers, the second of the Great 12 livery companies of the City of London. The transition from the pepperers to the grocers reflects the specific commercial history of the medieval spice trade. The grossari, the merchants who sold in gross, in bulk, and the modern grocery industry traces its institutional lineage through the Grocers' Company to the medieval pepperers. The concept of the grocer, the merchant who sells food and household commodities, is the medieval concept of the grossarius, the bulk seller, preserved in the specific word that the modern language uses for the shop and the person who runs it. The corner shop that sells your daily provisions is, etymologically, the medieval bulk spice merchant's descendant. The assize of bread, the medieval regulation of the price and weight of bread that the English crown maintained as one of its most important consumer protection measures, is one of the more remarkable medieval regulatory survivals in the food industry, because the specific principle it established, that the weight and price of bread should be regulated by public authority to protect the consumer from the baker's potential fraud, is a principle that the modern food standards legislation maintains in the specific form of the weights and measures and food labeling requirements that govern the sale of bread today. The medieval assize of bread was enforced through the pillory. The baker who sold underweight bread was put in the pillory with the deficient loaves hung around their neck, the public humiliation serving as both punishment and warning. The modern food standards enforcement is conducted through the trading standards officers and the court system, with fines rather than pillories. The enforcement mechanism has changed. The principle that the sold weight of the bread should be what it is represented to be is unchanged from the medieval assize. The specific weights and measures used in the medieval grain trade, the bushel, the peck, the quarter, are medieval units that the agricultural trade maintained through the centuries. The Winchester bushel, The specific bushel measure, whose standard was kept at Winchester from the medieval period, was the English standard measure for grain that the medieval assize of bread used to calculate the permitted bread prices, and the Winchester bushel's standard persisted as a reference measure in the English and American systems through the 19th century and beyond. The hop garden, the garden where the hops used to flavor and preserve modern beer are grown, is a medieval institution whose expansion in England dates to the 14th and 15th centuries, when the Flemish and Dutch brewing traditions' use of hops arrived in England and gradually replaced the gruit herbs that the earlier English ale tradition had used. The Worshipful Company of Brewers, the medieval guild of the London Brewers, was established in the 14th century and is still operating today, maintaining the medieval institutional form, while the brewing industry it represents has transformed beyond recognition. The specific rules that the medieval Brewers' Company established for the quality of beer, the requirement that the ingredients be pure, the requirement that the vessels be clean, the requirement that the measure be honest, are the medieval institutional expression of the same consumer protection principle that the modern food safety legislation pursues. The Reinheitsgebot, the Bavarian purity law of 1516 that specified beer could only be made from water, barley, and hops, is the most famous medieval food regulation still formally operative in the modern world. The German brewing industry proudly maintains the Reinheitsgebot as a quality standard, and the medieval Bavarian law's requirement that beer be made from pure ingredients is still cited in the marketing of German beer, 500 years after Duke Wilhelm IV of Bavaria enacted it. The craft brewing revival of the early 21st century, the movement that has produced thousands of small breweries across Europe and America, making beer in styles and with ingredients that the Reinheitsgebot would have prohibited and that the medieval gruit tradition would have recognized, is both the reaction against the industrial standardization of brewing and the specific return to the medieval tradition of local small-scale, ingredient-diverse brewing that the industrial period had replaced. The medieval feast day calendar, the liturgical calendar of the church that specified the fast days when meat was prohibited and the feast days when the best food was served, organized the food year in ways that the modern secular calendar still partially reflects. The Christmas feast, the elaborate celebration meal that the medieval calendar required at the conclusion of the Advent fast, is the modern Christmas dinner, whose specific dishes vary by national tradition, but whose function as the year's most elaborate food event is the direct continuation of the medieval feast day tradition. The Shrove Tuesday pancake, the specific dish of the day before the Lenten fast begins, is the medieval tradition of using up the eggs and fat that the Lenten fast prohibited, the specific culinary logic of the pre-fast clearance encoded in the annual pancake tradition that millions of modern people maintain, without necessarily connecting it to its medieval religious origin. Shrove Tuesday is still Pancake Day. The medieval Lenten fast is still the indirect cause of the annual consumption of pancakes. The Christmas goose, the traditional Christmas dinner bird that the Victorian tradition popularized, but that has roots in the medieval feast day tradition, is the medieval feast animal of Michaelmas and Christmas. The goose that the medieval agricultural calendar produced in abundance in the autumn, and that the feast day tradition made the specific meal of the season. The turkey, which the American tradition adopted as the Thanksgiving and Christmas bird, and which the British Christmas tradition gradually replaced the goose with from the 19th century onward, is the New World replacement for the Old World goose. But the tradition of the special bird for the special feast is the medieval tradition, the specific rule that the sovereign's Christmas speech should be broadcast to the nation. The royal Christmas message that the British monarch delivers each year is not medieval, having been established by George V in 1932 with the first radio broadcast, but the tradition of the monarch's public address at Christmas is the modern institutional expression of the medieval royal feast, the specific royal public presence at the major feast of the calendar that the medieval Christmas required. The wassail, the traditional English winter drink of spiced ale or cider, consumed while singing in the apple orchards to encourage the next year's harvest, is a medieval tradition that the folk revival of the 20th century recovered, and that is now practiced in the orchards of the West Country in the specific medieval form of the ceremony. The wassail bowl, the wassail song, the toast to the apple trees. These are the medieval agricultural rituals of the cider-making tradition, maintained in their medieval form by the specific communities that have preserved them and revived by the folk tradition movement that found them. The modern craft cider industry's revival of traditional apple varieties, the specific heritage apple cultivars that the medieval and early modern orcharding tradition had developed, and that the industrial apple production of the 20th century had largely replaced with a small number of commercial varieties, is the agricultural equivalent of the craft beer revival, and it is recovering the medieval and early modern biodiversity of the orchard in the specific idiom of the heritage food movement that values variety and locality over standardization and scale. The Worshipful Company of Fruiterers, the livery company of the London fruit trade, established in 1605, but building on the earlier medieval guild tradition of the fruit merchants, still regulates aspects of the London fruit trade and maintains the medieval institutional form of the livery company in the modern commercial context. The fruit merchant of the 21st century is the institutional descendant of the medieval fruiterer, and the specific guild that the medieval fruiterers established has maintained its institutional existence through 4 centuries of transformation. The medieval spice routes, the specific trading networks that brought pepper and cinnamon and nutmeg and cloves from the spice islands of Southeast Asia through the Arab merchants and the Italian trading cities to the markets of Northern Europe, shaped the specific flavor profile of the medieval European cuisine in ways that are still visible in the traditional foods of the regions that maintained the medieval spice tradition. The gingerbread of the medieval feast, the heavily spiced bread sweetened with honey that was the prestigious sweet food of the medieval court, is the ancestor of the modern gingerbread, baked at Christmas in the medieval shapes of the star, and the man that the tradition has maintained. The spiced wine of the medieval feast, the hippocras, the medieval mulled wine of honey and warming spices, is the ancestor of the modern mulled wine, the vin chaud, the glühwein that the modern Christmas market sells in the specific seasonal idiom that the medieval feast day tradition created. The hot spiced wine, served in the cold winter months, is the medieval thermal management strategy encoded in the modern Christmas tradition. The warming drink of the medieval feast surviving in the 21st century market stall. You are eating and drinking the Middle Ages. Every Christmas dinner, every glass of Burgundy, every loaf of bread weighed to the regulation standard, every craft beer made in the tradition of the medieval brewer. You are consuming the continuity of the medieval food culture in the specific, eatable, drinkable form that makes it the most directly accessible survival of the age that produced it. The medieval world made food, and the food it made is still being made. Raise a glass of mulled wine to it. The medieval brewer would have approved. Chapter 14. The Body and Medicine. The Medieval Health, Rules, and Medical Traditions that survived into the modern world. Your doctor is still using medieval ideas, not primarily. The modern physician works within the framework of evidence-based medicine, germ theory, molecular biology, and the extraordinary accumulated knowledge of the past 2 centuries of scientific medicine. But embedded in the practice, the language, the institutional structure, and the specific habits of the medical profession are survivals from the medieval period that the history of medicine has preserved in ways that most modern patients and many modern physicians don't fully recognize. The medical degree, the specific academic qualification that licenses the physician to practice, is a medieval institution. We have discussed the medieval origins of the university degree in the previous chapter, but the medical degree has its own specific history that the medieval faculties of medicine at Bologna, Paris, Montpellier, and Salerno established. The specific structure of medical education, the period of theoretical study, followed by the period of clinical practice, the examination before a board of qualified practitioners, the formal licensing that the completion of the process confers, is the medieval structure maintained through centuries of reform and expansion, but recognizable in its essential architecture as the medieval institution. The specific oath that medical graduates take, the Hippocratic Oath, or one of its modern descendants, is a document whose origins lie in the ancient Greek medical tradition, but whose use as the specific moral framework for medical practice was formalized in the medieval period. The medieval medical faculties incorporated the Hippocratic tradition into the curriculum and into the ethical framework of the profession, and the specific commitment to the patient's welfare, the specific prohibition on doing harm, the specific obligation of confidentiality. These are the Hippocratic principles that the medieval medical education transmitted to the modern world through the unbroken institutional continuity of the medical schools. The word physician, the doctor who practices internal medicine, is the medieval word from the Latin physicus, the person who studies nature and its effects on the human body. The medieval distinction between the physician, the learned doctor who diagnosed and prescribed, and the surgeon, the practitioner who performed manual operations, is the distinction that the modern medical profession has maintained in modified form. The specific separation between medicine and surgery that the medieval guild and university structures enforced, and that the modern hospital's organizational structure still reflects. The barber surgeon is the medieval practitioner whose institutional history illuminates the specific social and professional history of surgery. The medieval separation between the learned physician, who was educated at the university and who treated disease through prescription and diet advice, and the manual practitioner who performed bloodletting, wound treatment, tooth extraction, and the various surgical operations that the medieval body required, produced the specific class of the barber surgeon, the craft practitioner who combined the cutting of hair with the cutting of bodies in the specific, pragmatic combination that the medieval guild structure had organized. The red and white striped pole that is the traditional sign of the barber shop, the red representing blood, the white representing the bandages, is the medieval barber surgeon's sign, preserved through the centuries as the barber's mark, even after the surgical function of the barber's shop was separated into the professional surgery that the 18th and 19th centuries reorganized. The modern barber who cuts hair under the red and white pole is maintaining the visual sign of the medieval practitioner who cut hair and bled patients at the same establishment, the sign surviving the function by several centuries. The Worshipful Company of Barbers, one of the oldest livery companies of the City of London, with a royal charter dating to 1462, was originally the Guild of the Barber Surgeons of London, and it maintained its joint jurisdiction over the barbers and the surgeons until 1745, when the surgeons separated to form the Company of Surgeons, which became the Royal College of Surgeons in 1800. The Barbers' Company still exists as a livery company, still occupies Barber Surgeons Hall in the City of London on the specific site that has been associated with the Barbers Guild since the medieval period, and still maintains the specific connection to medicine through its charitable support of medical education. The specific bloodletting tradition, the medieval practice of removing blood from the patient to restore the humoral balance that the illness had disrupted, is not, obviously, still practiced. The humoral theory of medicine, the framework of four humors whose balance determined health and whose imbalance produced disease, was the theoretical framework that the medieval medical tradition inherited from the ancient Greeks, and that the medical education of the medieval university transmitted as the authoritative understanding of the body's functioning. The humoral theory is wrong in its specific mechanism, and the medical treatments it generated, the bloodletting, the purging, the dietary adjustments designed to correct humoral imbalance, are not the treatments that modern medicine uses. But the humoral tradition left a specific linguistic legacy in the modern vocabulary of emotion and personality that the everyday language maintains. The word sanguine, optimistic, Cheerful is the humoral word for the person in whom the blood humor dominates, the specific personality type that the humoral tradition associated with the sanguine temperament. The word melancholy, deep sadness, depression, is the humoral word for the person in whom the black bile humor dominates, the melancholic temperament of the humoral tradition preserved in the modern word for the emotional condition. The word choleric, angry, irritable, is the humoral word for the person in whom the yellow bile humor dominates, the choleric temperament of the humoral tradition preserved in the modern adjective for the quick-tempered person. The word phlegmatic, calm, unemotional, slow to react, is the humoral word for the person in whom the phlegm humor dominates, the phlegmatic temperament of the humoral tradition preserved in the modern adjective for the calm, imperturbable personality. These four words, sanguine, melancholy, choleric, phlegmatic, are the medieval humoral theory's most direct survival in the modern language, the specific personality categories of the medieval medical framework preserved in the everyday vocabulary that the modern person uses to describe character and emotion without necessarily knowing that they are using the terminology of a 2,000-year-old medical theory. The quarantine is a medieval institution whose origin is directly traceable to the specific medieval response to the Black Death. The word comes from the Italian quarantina, the period of 40 days, the specific duration of isolation that the Republic of Venice imposed on ships arriving from the plague infected Eastern Mediterranean in 1377. The 40 days was the biblical period of trial and purification, and the medieval understanding of the plague as a divine punishment that required the specific purification of the isolated period informed the specific choice of the duration. The modern quarantine, the specific period of isolation imposed on individuals exposed to infectious disease, is the direct descendant of the medieval Venetian institution, the specific infectious disease control measure that the medieval Republic of Venice developed in response to the plague crisis of the 14th century is the measure that the modern public health system deploys in response to the infectious disease emergencies of the 21st century. The word quarantine is the Italian number 40, the medieval religious significance of 40 days encoded in the modern public health vocabulary. The lazaretto, the isolation hospital for the infectious disease patient, is another medieval Venetian innovation developed in the same plague management context as the quarantine. The first lazaretto was established on the island of Santa Maria de Nazareth in the Venetian lagoon in 1423, and the word comes from the Venetian contraction of the island's name. The modern isolation ward, the modern dedicated infectious disease hospital, the modern facility for managing highly contagious patients. These are the 21st century descendants of the medieval Venetian lazaretto. The specific institutional form of the hospital, the dedicated building for the care of the sick, organized around a professional staff with specific medical training and a specific therapeutic mission, is a medieval institution. The modern hospital's medieval origins are documented in the specific charitable hospitals that the medieval church established. The Hôtel Dieu in Paris, founded in the 7th century and still operating, making it the oldest hospital in the world. St. Bartholomew's Hospital in London, founded in 1123 and still operating as a major London teaching hospital. St. Thomas's Hospital in London, founded in the 12th century and still operating. Bart's, St. Bartholomew's Hospital, is the oldest hospital in England, still providing medical care on its original site. It was founded in 1123 by Ranieri, a courtier of Henry I, who fell ill on a pilgrimage to Rome and made a vow to found a hospital if he recovered. The specific medieval charitable impulse, the sick person's vow of foundation, the religious house that provided the nursing, the charitable endowment that funded the care, is the institutional origin of the hospital, that the modern National Health Service now operates on the same site. The medieval institution and the 21st century public health system share a location and an institutional lineage. The nursing tradition has medieval origins in the specific religious orders that the medieval church established for the care of the sick. The nursing sisters of the medieval hospital, the religious women whose vowed service to the sick was the specific institutional form of the medieval nursing care, are the institutional ancestors of the modern nursing profession. The Florence Nightingale reform of nursing in the 19th century was partly the reform of a profession whose institutional structure had become disorganized, and partly the recovery of the disciplined, trained, professionally organized nursing care that the best medieval hospitals had maintained in the specific idiom of the religious order. The specific Nightingale ward, the large, open-plan hospital ward with the patients arranged in rows on either side, and the nursing station at the end, is the architectural translation of the medieval hospital ward, the long hall of the medieval charitable hospital, whose design reflected the specific liturgical requirements of the medieval institution as much as the medical requirements of the patients. The medieval hospital ward was oriented to allow the patients to see the altar at the end of the hall, so that the religious services that the nursing sisters performed could be observed from all the beds simultaneously. The Nightingale ward's orientation is the secular descendant of this medieval design. The apothecary, the medieval pharmaceutical practitioner who prepared and dispensed the remedies that the physician prescribed, is the direct ancestor of the modern pharmacist. The Worshipful Society of Apothecaries, established by royal charter in 1617, but building on the medieval tradition of the Apothecaries Guild, is still a licensing body for medical practitioners in the United Kingdom, granting the licentiate of the Society of Apothecaries qualification that is one of the specific medical licenses that the UK General Medical Council recognizes. The medieval apothecary's institutional descendant is still licensing doctors in the 21st century. The herbal tradition, the specific pharmacological knowledge of medicinal plants that the medieval monastery gardens preserved and that the medieval herbals transmitted, is the ancestor of the modern pharmacopoeia, the official list of medicines whose composition and preparation the pharmaceutical standards specify. The medieval herbals list of plants and their medicinal properties is the ancestor of the modern drug compendium, and many of the specific plant-derived medications that the modern pharmacopoeia includes are the specific plants that the medieval herbal tradition identified as medicinally active. The specific active compounds of many modern medicines are the compounds that the medieval herbal tradition had empirically identified as effective without understanding the chemical mechanism of their action. The digitalis glycosides, the cardiac medications derived from the foxglove plant, were identified as medicinally useful in the folk and herbal tradition long before the 18th century physician William Withering systematized the observation in his 1785 account of the foxglove. The medieval herbalist who prescribed foxglove preparations for the swollen legs and the labored breathing of the failing heart was prescribing the right treatment for the right condition without the biochemical explanation of why it worked. The aspirin, acetylsalicylic acid, the most widely used medication in the world, is the synthetic derivative of the salicylic acid found in willow bark, and the use of willow bark preparations for fever and pain relief was documented in the medieval herbal tradition, in the ancient Greek medical tradition before it, and in multiple traditional medicine traditions across the world. The medieval apothecary who prescribed willow bark tea for fever was prescribing the natural source of the compound that the 19th century pharmaceutical chemist would eventually synthesize, and that the 20th century would distribute in the familiar white tablet. The medieval tradition of the uroscopy, the examination of the patient's urine as the primary diagnostic tool of the medieval physician, left a specific legacy in the modern medical tradition's continued use of urinalysis as a diagnostic procedure. The medieval physician who held up the urine flask, the matula, the characteristic flask that became the symbol of the medical profession in the medieval period, and assessed the color, clarity, and smell of the urine, was doing a simplified version of the urinalysis that the modern laboratory performs with considerably more precision. the diagnostic principle that the composition of the urine reveals something about the body's internal condition, is unchanged from the medieval practice. The technology of the analysis is dramatically different. The specific institutional tradition of the medical consultation, the formal meeting between the patient and the physician, in which the patient's condition is assessed and the treatment is prescribed, is the medieval clinical encounter, formalized in the medieval university's teaching of the consultation procedure. The medieval physician's consultation had the specific structure of the anamnesis, the taking of the patient's history, the physical examination, and the prescription. And this structure is the structure that the modern clinical encounter still follows in its essential form. The patient's expectation of privacy, the specific understanding that what is said in the consultation is confidential between the patient and the physician, is the Hippocratic principle that the medieval medical education transmitted, and it is the principle that the modern law of medical confidentiality maintains. The medieval physician's obligation of professional secrecy is the ancestor of the modern physician's legal and ethical obligation not to disclose the patient's medical information without consent. The specific ritual of the hand-washing that the modern surgical and medical practice requires, the specific protocol that the germ theory's discovery in the 19th century transformed from the optional to the mandatory, has medieval resonances in the specific ritual cleanliness that the medieval religious tradition imposed on the practitioners who move between the sacred and the potentially contaminating. The medieval hospital's requirement that the nursing sisters wash their hands before handling the Eucharist, the specific religious ritual cleanliness that the medieval church required in the handling of the sacred, may have had the incidental effect of reducing the transmission of infection in the hospital environment, though the medieval practitioner would not have understood the mechanism. The modern medical system is built on medieval foundations. The hospitals, the universities, the professional guilds, the pharmacological tradition, the clinical encounter, the confidentiality obligation, and the medieval survivals in the modern medical world are the specific institutional and intellectual continuities of the 7-century-old tradition that the medical profession has maintained through the extraordinary transformations of the intervening centuries. The next time your doctor examines you, in the hospital founded in the medieval period, with the qualification granted by the institution established in the medieval university, following the professional code that the medieval medical faculty transmitted, using the diagnostic principles that the ancient tradition and its medieval transmission established, you are receiving the care of a profession whose institutional history connects your 21st century consultation to the medieval physician's bedside by the unbroken chain of the institutional tradition. The Middle Ages are in the medicine cabinet. They are in the red and white striped pole outside the barber shop. They are in the quarantine measure the public health authority imposes. They are in the word sanguine you use to describe the optimistic friend and the word melancholy you use to describe your own dark days. The medieval medical world is the foundation beneath the modern one, invisible but present, the historical layer on which the modern practice stands, and from which it cannot entirely separate itself, because the institution and the language and the professional tradition carry the history in the specific, indelible way that the long past encodes itself in the living present. Your doctor may not know this, but the institutions know. They always have. Conclusion: the Middle Ages are not over. Not in the obvious sense. The castles and the plagues and the serfdom and the rather optimistic relationship with personal hygiene are, to the relief of everyone, historical rather than contemporary, but in the specific sense of the institutions, the laws, the ceremonies, the rules that the medieval period created and that the modern world has not got around to eliminating. In that sense, the Middle Ages are still here. They are here in the ceremony of the keys, performed tonight at the Tower of London for the 700th consecutive night. They are here in the hallmark on the gold ring in the jeweler's window, certifying the metal's purity with a mark whose function was established in 1300. They are here in the 3 readings of the bill in Parliament The 3 readings that the medieval assembly required because its members couldn't read the document for themselves. They are here, in the coronation oil applied to the monarch in the ceremony at Westminster Abbey, in the Latin formula of the Oxford degree conferral, in the feudal tenure that means you hold your house rather than own it. They are here in the salmon legislation and the geese on the common and the whale in the Thames, and the Lord Mayor of London shutting the door in the monarch's face. And they are here in the more serious places too, in the Magna Carta clause that the Supreme Court of the United States still cites, in the Geneva Conventions that trace their intellectual lineage to the medieval law of arms, in the corporation, the legal person, that the medieval canon lawyers invented to solve the church's property problem, and that the modern economy has built itself on. The medieval period had its share of terrible ideas, the ones this script carefully hasn't dwelt on, the ones that the subsequent centuries recognized as terrible and eliminated, but it also had, in the specific urgency of its practical problems, the specific creativity of its legal and institutional innovators, and the specific durability of the solutions it found, the capacity to produce ideas and institutions that have outlasted everything else about the world that produced them. The next time you stand on your land and feel the solid weight of ownership beneath your feet, you are standing on a medieval tenure. The next time you vote in an election for representatives who sit in Parliament, you are using a medieval institution. The next time you see the hallmark on a piece of jewelry, or read about a trial by jury, or watch the swan uppers go past on the Thames, you are watching the medieval world going about its business, 700 years after the world that produced it ceased to exist in any other form. The Middle Ages refused to fully end, and honestly, some of what they left behind is rather good.